Good evening and welcome, everyone. I am Lauren Toll, President of the Friends of the Bronxville Public Library. We are so delighted to host this author talk tonight. The Friends of the Bronxville Public Library is a nonprofit organization founded in 1986, dedicated to supporting, enhancing, and advocating for the Bronxville Library, a 145-year-old institution. Through public donations, we fund all the programs, sponsor special projects, and support any needs that are beyond the reach of the library's regular operating budget. I would also like to share the great news that last year, the Bronxville Library was recognized in the prestigious Library Journal for receiving the America's Star Library Award. Our library was one of the first in Westchester to reopen and has remained open ever since this difficult pandemic time. We'd like to thank our patrons for your support. Regarding the logistics for tonight's event, we have a lot of people signed up, so we kindly request that you mute yourself. And if you have any questions, please use the Zoom chat function. There will be some Q&A after the discussion. Now, on behalf of the Friends Board, I would like to welcome our moderator this evening, Sarah Norman. Sarah Norman is a past president of the Bronxville Library Trustees and a longtime supporter of this beloved institution. Sarah joined the U.S. Attorney's Office for the Southern District of New York in 1999. She is currently Deputy Chief of the Southern District of New York's Civil Division. Prior to joining the U.S. Attorney's Office, she clerked for the Honorable Sonia Sotomayor on the U.S. Court of Appeals for the Second Circuit. And she also worked as an associate at Dewey Ballantine. Sarah is a graduate of Georgetown University and law school. Sarah will introduce the Honorable Jed Rakoff, Senior U.S. District Judge for the Southern District of New York, and they will discuss his book, Why the Innocent Plead Guilty and the Guilty Go Free, and other paradoxes of our broken legal system. This book, by the way, is available at the Wamrock Bookshop in Bronxville and at the Bronxville Library. Now let's get started. I'll pass Zoom over to both of you now.
Thank you very much, Lauren. And I do want to thank the Friends of the Bronxville Public Library for hosting this event and for all the wonderful work that you do for the library and for the community. It is my great pleasure tonight to introduce our guest, the Honorable Jed Rakoff, and the author of his book, Why the Innocent Plead Guilty and the Guilty Go Free. Judge Rakoff has served as a federal judge in the Southern District of New York in Manhattan for the past 25 years. And before joining the bench in 1996, Judge Rakoff was both a prosecutor and a criminal defense lawyer. He spent 7 years as an assistant U.S. attorney in the SDNY, where he was ultimately chief of the Business and Securities Fraud Prosecutions Unit. He then switched to the defense side and spent 16 years heading the criminal defense practices at two leading New York law firms, Mudge Rose and then Fried Frank. Having served as a prosecutor, a defense lawyer, and a judge, Judge Rakoff brings a special and unique perspective to the justice system and how it really works. I'd like to say on a personal level, I'm delighted to be here this evening and to have an opportunity to talk to Judge Rakoff. I've appeared before him many times in his courtroom. I know he's very good at asking questions. I'm sure he's going to be equally good, if not better, at answering them. Judge, welcome to the Bronxville Library virtually, and thank you for being with us.
So thank you, Sarah, for that very kind introduction. My wife, who's listening in, can now unmute and give the rebuttal, but perhaps not. I am very grateful to the Friends of the Bronxville Public Library for inviting me to be part of this program. It's, as I don't have to tell most of you, a beautiful library and a very well run and well-stocked library, and a real tribute to the community. But having described something that good, I want to turn to a brief review of what's in my book, which are things rather grim and not very pleasant. When I first went on the bench 25 years ago, I thought the legal system was basically pretty darn good. There were some tweaks that maybe were needed, but nothing major. But over the years, I was increasingly disturbed to see more and more very serious problems in my court, in the court of my colleagues, in the courts around the country. And finally, I felt that it was my obligation to try to bring these problems to the attention of people who might not have witnessed them firsthand. And that's why ultimately I wrote my book. And let me begin with a problem that probably is known to a number of you, and that is the terrible scourge of mass incarceration.
Terrific.
The United States leads the world in locking up people in jails and prison. Police states like China and Russia are no comparison whatsoever. We are number one, both in absolute terms and in per capita terms. For every year since the year 2000, we have averaged about 2 million or more people who we have locked up. And I'm hearing some people who need to mute themselves, please. This was not always the case. For many years, the United States was not a leader in incarceration. As late as 1960, we had no more than 400,000 people in our jails and prisons in most years. And then it started rising till by the year 2000, it was 5 times that amount. Why did that occur? Ultimately, it was the reaction to rising crime rates in the late 60s, 70s, and 80s. And in reaction to that, Congress and the state legislatures passed very harsh laws, mandatory minimums forcing judges to give sentences of 5, 10, 15, 20, even 40 years. Career offender statutes so that if you committed even 3 minor felonies, you went to prison for life. Very harsh sentencing guidelines that for their first 15 years were mandatory, and so forth. And this is what led to this huge increase. Now, starting in the year 1996, crime rates began coming down, and they have continued coming down every year except this past year, and because of the pandemic, there was an increase. But even though crime rates decreased to levels not seen since the early 60s, the mass incarceration remained at the 2 million level, meaning that we were locking up an ever greater percentage of people who were arrested for an ever greater period of time. There's also a racial aspect to this. 40% of those 2 million people are young African-American males between the ages of 18 and 34. Another 20% are young Hispanic males of similar ages. They are being ripped from their communities at a critical time in their lives, ripped from their families. And what are they becoming? They're becoming, frankly, better criminals because that's what prison often does. So this is really a terrible situation. I hope we get later to describing some of the cures that might fix this problem. But let me go on to say that these very harsh laws that were passed with bipartisan support in the 70s and 80s and 90s have another side effect, which is not as well recognized, which is they've effectively done away with jury trials. Before these laws were passed, between 20 and 25% of people in the United States who were accused of felonies went to trial, exercised their constitutional right. But now, and since the year 2005, it's been 3%. Virtually no one goes to trial anymore. And that's because they are facing, if convicted, these harsh mandatory penalties that a judge can do nothing about. And it's just not worth the risk. And as you might expect, a corollary to that is that a fair number of innocent people plead guilty to crimes they never committed at all. We know this for a fact. This is not just a hypothesis. For example, the Innocence Project, which over the last 20 years has, through the use of DNA, exonerated more than 400 people, mostly of very serious crimes like murder and rape, reports that 10% of those people pled guilty to crimes they had absolutely nothing to do with. There's even a larger measure, something called the National Registry of Exonerations, which records all court-ordered exonerations in the United States since 1989. It's up to now something like 3,000. It reports that 20% of the people in that list pled guilty to crimes they never committed. Now, even if we take a very conservative view and say, well, maybe those figures are a little high because lawyers maybe were attracted to trying to prove the innocence of someone in those cases, and just say 5%. 5% times 2 million, that's 100,000 people who are now in our jails and prisons for crimes that they never committed at all. And I suggest to you that is completely unacceptable.
Can I ask, why would someone plead guilty to a crime he or she did not commit?
So as a defense lawyer, I was representing some of these folks when these laws began to come into play. And here would be the situation. You would typically get involved with your client the day after he was arrested. And frequently, in fact, almost always, at that stage, he would say he was innocent. Some of those people were lying, but some were telling the truth. You would then go meet with the prosecutor, and the prosecutor, a young, well-intentioned person, but seeing things only from one side, would say, this is a slam dunk case. And if you go to trial, you know, you face a mandatory minimum of 40 years. But, you know, your client is not the biggest fish. I will give you a 10-year count, or maybe even a 5-year count. So you go back to your client and you say, you know, if you're innocent, I will defend you. I've already hired an investigator. We'll see, we'll make the best defense. And the client inevitably says to you, well, what are my chances of acquittal? And no defense lawyer can ethically say anything more than, well, I think you've got a decent shot. But that's about it. You can't say it's 90% certain. And I'll allude later to why, in fact, even if you are innocent, it won't be anything like 90% certain. But in any event, you give them that. And you've already told them, as you're required to do, that the prosecutor is willing to give him a 10-year count or a 5-year count. And you've told them that if he's convicted, he will face 40 years. And he does in my view, wholly rational cost-benefit analysis and says, you know, I'd rather do the 5 years than face the risk of 40 years. And that's why innocent people plead guilty. And ultimately traces back to these very harsh laws. Let's talk, though, a little bit about those people who do go to trial. It used to be believed, and I believed it as a young prosecutor, that the chance of someone being convicted at trial with all the protections, proof beyond a reasonable doubt, presumption of innocence, and so forth, was remote. But that proves not to be the case. There have been all these exonerations. And the Innocence Project and the National Registry of Exonerations both report that there are two major causes for those wrongful convictions. One is bad forensic science. I got muted for a second. Thank you. So there are two causes for wrongful convictions at trial, more than two, but the two most common. About 1/3 are the result of bad forensic science, and as many as half are the result of bad eyewitness identifications. You think about good forensic science like DNA, which has led to many exonerations, but in most cases, you're talking about something much more problematic, something highly subjective, like bite mark evidence, like hair analysis. The National Academy of Science issued a report in 2009 examining all these forms of forensic science, and they concluded that most of them had never been meaningfully tested in a scientifically reliable way, that they involved a great deal of subjectivity, and yet they had a big impact on juries. As the exonerations mounted, the FBI, to its credit, finally did a study of the 3,000 cases in which its own experts had testified to a hair match, saying that microscopically the hair found at the scene of the crime matched the defendant and only the defendant's hair. And they concluded that in 95% of those cases, their experts were either wrong or had materially overstated the degree of matching, 95%. Now, let's talk about eyewitness identification, which is even a bigger problem. Everyone knows that there can be bad eyewitness identification through poor lighting or bad vision. The great movie, My Cousin Vinny, has many good examples of this. But again, the National Academy of Science has demonstrated that there are many more subtle effects that lead to bad eyewitness identifications that really we can't do much about. And I'll give just one example, which is the so-called merger effect. So you're an eyewitness, you see a crime being committed, you're probably focused on the weapon if there's a weapon being used, but you may see the face of the perpetrator for a minute or two. And if someone could take a picture of your brain at that point, the inner workings of your brain, they would see that you only have a fuzzy perception and memory of the face of the perpetrator. But maybe a couple hours later, the police will show you a photo array. Sometimes they use a lineup, but these days it's more a photo array, 5 or 6 or 7 photographs, and all of which look somewhat alike. And they will say, do you see anywhere in these photographs the person who you think committed the crime? And you will study those very carefully because you want to be a good, honest witness. And you will notice that the person who looks the most like the person you saw, although you're still a little uncertain about it, has a scar above his right eyebrow. And so you will say, I think it's number 2. I'm not sure, but I think it's number 2. 3 months later, when you're in the grand jury and the prosecutor's getting an indictment, or a year later when the case goes to trial, you will say, I am absolutely sure it was whoever corresponds to number 2, because I will never forget that scar above the right eyebrow. And what has happened unconsciously is the two memories have merged. It's a human tendency. There's not much you can do about it. I'll suggest later some ways we can deal with it as a legal system. But it's not like you're being dishonest, but you are wrong. And many innocent people get convicted as a result. I want to mention just 2 other problems that I deal with in my book, and then turn it over to Sarah, to your fearsome questions. The first is the double standard. Like many countries, I'm afraid, our law applies one way to the poor and a different way to the rich. And with the poor, we're very harsh. We lock up all those people. With the rich, we frequently don't prosecute at all. And the most vivid example of this is high-level executives who were involved in major financial crimes following the financial crisis of 2006, 7, and 8. In the old days, when I was a prosecutor, and therefore the good old days, we went after the highest level person we could. And the Department of Justice in the 1990s and early 2000s successfully prosecuted the CEO of Enron, the CEO of WorldCom, the CEO of Tyco, the CEO of Adelphi, and so forth. But those took a lot of time and a lot of person power to make those cases. And the government then discovered around 2006 or so that it could go after the company much more easily than going after the individuals, because under federal law, at least, the crimes of even a low-level person are automatically imputed to the company. And so they would bring in the company, they would cut a deal, sometimes a deferred prosecution, sometimes a guilty plea, and they held a big press conference 6 months later. There would be a $2 billion fine, there would be compliance measures, but they would never go after the high-level people who may have orchestrated those very serious financial frauds. And this, in my view, was a very poor solution. The fines, the big fines, were paid ultimately by the shareholders, who were typically completely innocent. The compliance measures have been studied now in many, many cases and have been found to be relatively of only modest effect. There's been a whole lot of recidivism. But the most problematic aspect of all this is that the people who ultimately had the responsibility to stop these crimes and who could have been charged criminally are just completely forgotten about and never gone after. So it's the double standard operating. And the very last problem I want to mention has to do with our civil law system and the fact that we lawyers have priced ourselves out of the market in terms of everyday folks. The statistics, again, are quite telling. The lawyers' rates have risen at 3 times the rate of inflation for several decades now. The average partner in a law firm in the entire United States charges over $500 an hour. In New York, of course, it's more like $1,000 an hour. Most people can't afford that. I certainly can't. And in the 2 courts where most people wind up, if they're everyday folks, housing court and family court, either because they've got a landlord-tenant dispute or because they're being subject to eviction or forfeiture of their mortgage, or because they have a divorce or a custody battle or some other family court dispute. In those 2 courts across the United States, 2/3 of the individuals who are involved in those cases, typically as defendants, do not have a lawyer at all at any stage. And it makes a huge difference. In those cases where individuals have a lawyer, they win about half the time. In those cases where they don't have a lawyer, they win only 5% of the time. We have created a legal system that doesn't do justice to everyday folks. So with all those grim messages, I will later on perhaps get a chance to allude to some of the solutions, but let me shut up and turn it over to you, Sarah.
Well, I do want to ask you actually about some of the solutions, because I think you have some ideas in your book that are new and really interesting. And in terms of mass incarceration in particular, I'm wondering, what do you think needs to change, and what, more importantly, realistically can change to address this problem? Because, and I say that, particularly with the sort of intractable political situation we seem to have in this country, one could despair about dealing with this problem, and yet there are some signs of progress.
Well, of all the problems I've described, that's the one that has the easiest solution if it were politically viable, and that is just to repeal all those mandatory minimum career offender and other harsh laws that I mentioned before. The problem is getting tough on crime has always been good politics in the United States, and being soft on crime often is a disaster politically. Nevertheless, there was beginning to develop a few years ago, at least a recognition of some of the problems of mass incarceration. And Congress, in 2018, in a bipartisan move, passed what was called the First Step Act, which reduced a few of the mandatory minimums. And it was called the First Step Act because it was anticipated that if it proved successful, there'd be many other steps. Well, no other steps were ever taken. And I worry that with crime rates having gone up in the last year, that it will be politically difficult to have a second step or a third step. But that is the real solution. I have some other more modest steps that could be taken that would be helpful. And the one that really is derived from the system in England, but it's a good idea nonetheless, is I would have every prosecutor be required to spend 6 months out of every 3 years as a criminal defense lawyer for indigent defendants in another district. It would have to be in another district to avoid conflicts. Because I think most prosecutors who now have this tremendous power as a result of these laws that they now wield are well-intentioned people, but they're not very experienced in seeing both sides. They're young folks. They are being told by the police and by the FBI, here this is an open shut case. They're not really open to internalizing the fact that they may be wrong and that there may be something to be said for looking more deeply into these cases. Whereas if they were criminal defense lawyers for even 6 months out of every 3 years, they would get a much better feel for both sides of the coin. And this is the system in England where a barrister can be the prosecutor in one case and a defense lawyer in the next case. And I think that would be a very helpful step here. One final step is I think much more training could be done of prosecutors as to the limitations of our legal system. So again, taking eyewitness identification, for example. The problems there are in the human perception and memory. It can't easily be solved, but prosecutors can be made aware of them through training early in their careers. Even in my view, a half-day video training on some of the problems with eyewitness identification would make a huge difference in how they view eyewitness identification. In the cases involving eyewitness identification where there have been exonerations, typically the perpetrator was found ultimately to be someone who was another suspect, but was not pursued because the police had such confidence in the eyewitness identification. And once prosecutors knew that, once police knew that, because they should be trained in this as well, they would be a little more skeptical of the eyewitness identification and would pursue maybe some other leads that might in the end prove more fruitful.
At the federal level, do you find that juries are typically getting it right in the cases that you're presiding over? In other words, when you're sitting through a trial and you get to the end and the jury renders a verdict, do you typically agree with that verdict and think the jury has gotten it right? And I ask the question because I would think that many of these issues with regard to eyewitness identification and the limits of forensic science and the like would frequently be the subject of cross-examination at trial, at least at the federal level. And I'm wondering whether you think juries are able to, if they have an effective cross-examination, weigh these factors properly.
So on the whole, I do think juries get it right. I'm very disturbed at the complete almost obliteration of jury trials because also that's where the system really gets tested. That's the one place where there's total public scrutiny of what's going on. I think in civil cases, juries sometimes are too generous. It's other people's money. And if they're sympathetic to the plaintiff, they may feel very good about giving away it's only insurance money after all. But in criminal trials, I think they usually do get it right. However, in the cases where there have been wrongful convictions, often the defense attorneys, were not really aware of the problems with eyewitness identification. We're not really aware of the problems with bite marks and hair analysis. We're not aware of all these things that the National Academy of Science has so ably presented. The National Academy of Science had a different suggestion to deal with that problem, and one that I like a lot, which was to create a National Institute of Forensic Science that would be staffed by very high-level scientists who would determine generically whether this kind of forensic science could be admitted, whether this type of forensic science could not be admitted, whether it was good science, bad science, whether in the case of bad science it could be improved and how it could be improved, things like that. Because I do think that one of the reasons that defense counsel don't educate juries that much about this is because they're not scientists. They don't understand many of the difficulties. It would be much better to put it into the hands of the scientists.
Interesting. I'd like to ask you about sort of what your thoughts are and how improvements could be made in access to justice on the civil side, because you mentioned that toward the end of your discussion, and it is clearly a problem. And one wonders whether there should be some kind of a right to counsel in at least some subset of these kinds of cases where basic human needs are at stake, housing cases, foreclosure cases, and the like.
Well, New York City has experimented with having appointed counsel for indigent people in housing court. The problem is that's very expensive. So I don't think it's likely to be adopted in many states and communities just because of the expense involved. And it doesn't help people who aren't indigent, but who still can't afford lawyers, working class people. So I have two suggestions. One would be a great expansion of legal insurance. We have Medicare, we have Obamacare, and so people, by and large, don't have to worry the way they once did about getting health insurance. I think with a little urging and maybe backing from the government, you could have much more widespread legal insurance. There are a little bit out there, but it's not that common. A second thing would be to have the legal equivalent of nurse practitioners in the medical area. So these would be people who would go to law school, dare I say it, for maybe 6 months. If there are any law professors out there, sorry, I apologize. But I think that would be enough to learn the basics. They would then go through maybe an internship for another 6 months or so, an apprenticeship, so to speak. And then they could do simple legal matters. They could go into housing court. They could go into family court. No, they couldn't handle mergers and acquisitions. So there'd be no threat to the big law firms. But I think that would make a big difference. For that to happen, you would need the support of the law schools. I think they are the natural people to promote that solution. So those are two thoughts.
There already is a substantial amount of legal assistance being provided by law schools.
Well, that's true, but again, mostly for indigents. There's also, there's Zoom Legal and other online, but those people can't go into court. So if you want a contract, you go online and get the basics for doing this. But it's in court where this problem really exists.
One of the pieces of your book that really struck me was how frequently you call on your fellow judges to do more and speak more about the problems with the legal system, which struck me as unusual, and I wonder. I'm very curious to hear what feedback you've gotten from your brothers and sisters on the bench, but can judges, what are the opportunities for judges to speak and do more for these issues? And because many judges, I think, view themselves, or the public view them, as really, you're supposed to keep quiet and be neutral in your cases and not say anything that could be viewed as showing bias or any kind of political bent. And that's our usual understanding of where judges are. And your book is quite different, and you invite other judges to be more out there on those issues.
So that was a great concern to me when I first started writing about stuff like this. Because, as you say, the sort of the culture of the judiciary is we should only speak through our written decisions. Otherwise, we should stay out of the fray, so to speak. And I understand why that's a natural viewpoint. But if you look at the canons of judicial ethics, these are binding on federal judges. I'm not as familiar with state canons, but the canons of judicial ethics expressly permit judges to speak publicly and write publicly on problems with the due administration of justice. And the commentary to that says that you are asked to do that. It is encouraged. And before I started writing, I went to the canons of judicial ethics, so I didn't want to get in trouble. And I saw this, and it was a big encouragement to speaking out. And there have been, I'm certainly not alone, but it is true that it's still not as much as I would have hoped. I had another proposal to the plea bargaining problem, the problem that 97% of all criminal cases in the United States wind up being plea bargained. And judges in the federal system are forbidden to be involved with that. So I went to a few of the magistrate judges in my court, and I said, maybe we can get a pilot project that both the government and the legal aid, the federal defenders, will agree to. And so we'll agree that it will just be a pilot project, and it can pass muster despite the other prohibition. And that is that after an indictment is brought down, a magistrate judge will immediately have a conversation on the record, but under seal, first with the prosecutor, then with the defense counsel, and we'll find out what each side believes are the best facts, favorable or unfavorable to their side. And we'll initially suggest maybe leads that ought to be followed up, or maybe if it's a knowledgeable magistrate, why the eyewitness testimony isn't so good, or why the forensic science shouldn't be taken as strong as the both sides often are believing. And then the magistrate judge would meet with the parties maybe a second or third time, still early on in the case, and finally would suggest a non-binding plea bargain. It could suggest you should drop the case to the prosecutor, could suggest to the defense counsel, you might as well go to trial, it's your only hope. But could suggest in a great many cases, here's what I think would be a reasonable solution, which I'm sure would be much less onerous than what is now the case in many cases, would not be governed by mandatory minimums and things like that. And neither side would be required to follow it. It would just be a suggestion. It would never be known to the judge who ultimately tried the case if the case went to trial. This would all be kept secret, but it would be all recorded, so there could never be any suggestion of impropriety, and an appellate court could review it if there was any suggestion of impropriety. So I suggested it to a few of my magistrate friends, and they all said, get lost. And I said, why? And they said, because we're already too busy, and this would be a major problem in doing right. And we don't want it, if it's to be done, it shouldn't be done superficially. Well, I understand that, although I must say my not very politic response was, so you care about more doing discovery analysis in civil cases than in doing getting involved in where someone's liberty is involved. But despite that flip response, I do understand it would be a major burden, and therefore would require more magistrates and more judges. But
there would be an objection, Judge, from the party's perspective about sharing sort of work product and strategy, unlike in the civil side where there's so much disclosure up front and sort of fleshing out of what each side's position is. It's not unusual to go to a settlement conference and both sides give their pitch, and you're not really hearing anything new at that point. But my sense on the criminal side is that both the defense and the prosecutors sort of keep their strategy close to the vest.
Well, that's true, and that's a separate problem in itself. I mean, it's very strange that in civil cases where only money is involved, we have the world's most huge discovery, far greater than any other country. But when it comes to criminal cases, we have almost no discovery at all. But these would be separate conversations under seal, not available to the other side. And the magistrate would understand, like an arbitrator who tries to settle a case or something like that, okay, it's not right for me to give up the strategy of the other side to the other side. So, so I don't think that would be a problem. And I think the fact that it's a judicial officer involved would lead both sides to feel they need to be candid with the court, so to speak. But the result is that there is now no judicial involvement whatsoever in what is 97% of the criminal justice system, namely the negotiation of plea bargains. Zero. It's all done in secret. It's all done in the prosecutor's offices. There's no transcript. There's no meaningful review or usually any review. And how can we allow that to continue?
There's judicial review of the plea itself?
Yeah, that's pro forma, as any judge who's undertaken it will tell you. The average plea allocution, and this is for the entire United States, lasts 13 minutes. Of that 13 minutes, 9 minutes are spent telling the defendant all the constitutional rights that he's now agreeing to give up. And then there's a very quick colloquy in which usually both sides, the defense and the government, work out what the defendant is going to say in advance, so that it's just the bare bones, which is all that the government needs, and that's all that the defense wants to have surface because they want to save their bigger pitch for the sentencing. And so it is, in theory, a judge could inquire further. It's very hard for a judge to inquire further at that stage. And as a practical matter, they don't.
Mm-hmm. One of the suggestions you make is for there to be greater judicial discretion in imposing sentences, which obviously is not something that's within all the judges' control, but you also suggest that judges should speak up more about it.
So I think the sentencing guidelines, even though they're now non-binding in the federal system, although in some states they still are binding, are a big mistake. For the following reason. First, they rest on the assumption that you can put numbers on all the many, many factors that go into an informed sentencing. How do you put a number on how much of what the defendant did is a result of his unfortunate background? How can you put a number on, well, the victim was particularly hurt in this case because of the results? They just pick numbers out of the air, 2 points for this, 4 points for that. And because they use numbers, the Sentencing Commission is totally attracted to things that can be measured. And so 70% of the guideline calculation in drug cases are the weight of the drugs distributed. So you'll have a typical federal conspiracy, maybe 13 people. And the conspiracy as a whole distributed 10 kilograms of cocaine. You're going to have a huge guideline range, even though the guy at the lowest level may have been a courier who distributed 1 gram of cocaine in exchange for $100. And similarly, in white collar cases, 70% of the guideline calculation is the amount of loss. Now, amount of loss is not irrelevant. The weight of drugs is not irrelevant, but to make it the be all and end all is crazy. And I've had cases where first time white collar defendants faced life imprisonment under the guidelines because there was a loss of 10 or $20 million. That's a big loss. They weren't the only ones involved. Usually, sometimes they only pocketed a small percentage of that because they were not the main culprits, but they still faced life imprisonment, which, needless to say, I didn't give them now that the guidelines are no longer mandatory. And there's a final problem with the guidelines. The whole point of the guidelines was to do away with judicial disparities. Some judges were soft sentencers, some were harsh sentencers, and that everyone recognized. That didn't make a lot of sense. There is just as much disparity now with the guidelines, but no one sees it because it's disparity among prosecutors. So in the typical plea bargain, as I described it earlier, you may have a prosecutor who is sympathetic to the defendant and says, I'll give you a 5-year count. Or you may have a prosecutor who is tougher and says, the best I'm going to give you is a 10-year count. And you still take it because you don't want to go to trial and face a mandatory 40 years. Those two cases may be identical. But and the only difference is if you will, the ideology or psychology of the prosecutors. So there's tremendous variation there, even within particular offices, let alone between offices in different parts of the country. And the judges are completely unaware of it. So we have not solved the problem of disparity. We've just hit it.
So would you advocate getting rid of the guidelines altogether, or?
Yes.
You would.
Before you ask the rest of your question, before the guidelines came about, the Eastern District of New York, I'm in the Southern District of New York, but I've heard of the Eastern District. It's across the bridge in Brooklyn, and it's a great court, actually. Experimented with having weekly meetings of the judges of that court where they would discuss hypothetical cases that would raise difficult issues in sentencing. And in a way that was totally non-binding on anyone, they each, one judge would say, well, I think, that calls for 6 years. Another judge would say, no, I think it calls for 9 years. And they would discuss among themselves why they thought that. And I thought that was a terrific idea. And of course, the guidelines made that all a waste of time because they govern. But that's what I would substitute in place of the guidelines.
Yeah. Well, you anticipated my question, because I do think there is another kind of unfairness that's injected if you're, at the luck of the draw, getting a sympathetic judge versus a a law and order judge, and certainly in in the state system where you have judges who are elected who have as you talk about in your book, a great deal of incentive to be difficult on crime and tough on defendants.
There are studies that indicate that state elected judges at the trial level increase their average sentences by 20% in the year before their reelection. So there you go.
Wow. I want to ask you about something you haven't mentioned yet, but I found this chapter of your book among the most riveting and interesting, and that has to do with your views on the death penalty and how they've changed since you've been on the bench, both because of a personal connection to a violent crime and having presided over death penalty cases yourself. I'm wondering if you could talk a little bit about that.
Yeah, I used to be unable to talk about this because it did raise emotions, but I'm now sufficiently distant. So many years ago, my older brother, a wonderful person, a very talented person, in his early 40s, was bludgeoned to death. And if you had asked me then, would I have wanted the perpetrator who was caught to die, to be executed, I would have said, definitely, he doesn't deserve to live. He's forfeited his right to live. And I think that's a natural human reaction, and one that people who are opposed to the death penalty, as I am now, should nevertheless be aware of, and not think it's all just a question of ideology, for lack of a better word. There's a real moral force to that reaction. But what changed my mind was, again, the Great Innocence Project, where using DNA, they found that dozens and now hundreds of people who, in many cases, had been convicted of brutal murders, were facing the death penalty, or on death row. And in some cases, though we don't know this because it came too late, would have been exonerated even after they were executed, that they were innocent, totally innocent. And that was so mind-boggling to me. And so, because DNA and other testing often comes long after the fact, and it depends on the attorney, it depends what's available, it depends what's kept. There are many factors that go into it. And to execute someone and then discover, because of the DNA testing that came too late, that this person was actually totally innocent, is to me a very mind-boggling proposition, and more to the point, seems to me to deny that person due process. And I, in 2002, held the federal death penalty unconstitutional based on a Supreme Court case called Herrera, which I read as saying that it's never too late to prove that you are actually factually innocent. And of course, the death penalty does deprive you of that. And yet we know from the Innocence Project that often many people are innocent. I had no unrealistic expectations. I got reversed in a nanosecond. But I still think I was right. And I think, frankly, I think it will eventually be the law of the land. But we're not there yet.
I have to start wrapping up, unfortunately. We have some questions. I do want to ask you a few questions from our audience.
Yes.
One of which is has to do with recent changes in our drug laws, and the notion that because fewer people are being incarcerated for possessing low levels of drugs, marijuana and the like, will that make a substantial difference in the number of people who are sent to jail and who are incarcerated? Are we going to see changes in mass incarceration due to those legal changes?
That's my question, Jed. It's Carol.
So far, it hasn't made a big dent. I think there's this notion that mass incarceration is mostly people who were convicted of minor drug offenses. That's not true. It cuts across a great many offenses. Actually, the biggest decline in the last year in people incarcerated came in rural areas that historically had had some of the highest rates of incarceration, but which could not deal with treatment for COVID-19. And so the judges in those areas were facing the dilemma: do we send this guy to jail where his likelihood of getting the virus is very high because there's no social distancing and so forth, or do we let him out? And these were mostly bail cases rather than ultimate prison cases. But that's where even then it was not a big decline, but that's where the relatively biggest decline occurred. I don't think people realize, for example, that in the federal system alone, mandatory minimums, which were originally just in drug cases, now apply in 120 different felonies. So this is not just limited to minor drug cases. I applaud the efforts that are being made to let people out. And more importantly, many of these people are drug addicts and they need treatment. They're not antisocial psychopaths. They are not out to commit crimes because they love committing crimes. They, though, are desperate for treatment and said, what do? We send them off to prison where they join gangs and become, as I said before, better criminals.
A few of the questions actually relate to the notion of, the question of how many people who are currently incarcerated are incarcerated because of a physical threat to others or a crime that involves violence. And do you have a sense, or is there a way to quantify how many of those people in that category may have been wrongfully convicted?
Well, the Innocence Project has devoted itself totally to those kinds of crimes. In fact, almost all murders and rapes, the most heinous kind of crimes. And they have already found 400 people who were totally factually innocent, proven by DNA. And by the way, in most of those cases, the DNA showed who the real culprit was. So, this would be, for example, in a rape case, the fluid was taken from the vagina of the victim. It included semen. When given a DNA test, it turned out it wasn't the guy who was convicted on other grounds beyond a reasonable doubt and all like that. But it was the semen of someone who was in the system, because there is a huge FBI database for DNA. And lo and behold, they then went after that guy because there's no statute of limitations for murder. And usually that guy then confessed.
Judge, I need to close there. Thank you very, very much. I read the book with great interest, and I must say it's not only fascinating, but also a great read. It's really wonderful, and I encourage all of you to read it. Lauren, let me send it back to you. Thank you, Judge.
Thank you.
We just want to thank Judge Rakoff and Sarah Norman for such a fascinating conversation. I could listen for another hour, I think. We'd also like to thank Christine Uchel and Irina Stern for making the event possible tonight. And thank you to all of you for joining us. If you haven't read the book, it's not too late. You can still get the book at Wamrat's Bookshop in Bronxville. And please keep an eye out for our next author talk. We're still working on it, but it should be exciting. Good night, everyone, and thank you so much for joining us.
Thank you.
Judge.
Thank you, Judge.
Thank you.
Thank you.
Thank you. Thank you. Great moderator.
Thank you. It was terrific. Okay. here. Peggy Herzog. Carol, I don't know. Oh, I know who that is. Kay Donahue. I don't know these people.
Are you still on mute? Don't make comments.
No, no, I unmuted myself. And I said, thank you.